So good morning and welcome to Estate Administration Week. My name is Matt Mandrusiak and I am a donor advisor with the Edmonton Community Foundation. It is my pleasure to be your host for this session, and we are so happy that you could join us. Many of you are already familiar with our annual Wills Week held every October. This week, we are launching a new series of presentations similar to those you've attended in the past, but with a specific focus on the ins and outs of effectively administering an estate. At Edmonton Community Foundation, our role is to help people create their legacy for our community, and we are a trusted resource for Edmontonians to provide ongoing endowment support for the organizations and issues they care about. As a result, we have many conversations with people in our community about their will and estate plans, and we know how important it is for people to learn valuable information from wills and estates professionals. Just before we introduce our presenter for today's session, I would like to let you know that at the end of this session, you will be given the opportunity to complete a survey. As this is our first time hosting Estate Administration Week, your feedback is valuable to us and will help us plan for next year and beyond. I'll also just let you know that as the presentation rolls out today, there are going to be opportunities for you to ask questions to be answered. So I do ask that if you have some questions throughout the presentation, feel free to type them into the Q&A box. I will be monitoring those questions throughout the program. It is possible that our presenting lawyer will take some pauses throughout her presentation to answer questions, but we will certainly have time towards the end of the presentation to circle back and answer some of your questions. And as I mentioned off the top, for anyone who was in the in the meeting early, we are recording this session. All of the sessions that we are hosting this week will be posted to the ECF website by the end of April. So pay attention for that to be, those resources to be added to our site within the next couple of weeks. And okay, without further ado, you don't want to hear from me anymore. So I am going to introduce our presenting lawyer today, Patty Coe. Patty graduated in 2003 with a Bachelor of Commerce from the University of Alberta, and with her LLB, a Bachelor's of Law degree from the University of Alberta in 2006. She was then called to the Alberta Bar in 2007 and is currently a member of the Law Society of Alberta and a member of the Canadian Bar Association. Patty is an associate with Bishop MacKenzie, and her practice area includes wills and estates, trusts and wealth management, and civil litigation. With an undergrad degree in commerce and accounting, Patty brings an understanding of business practices and operating challenges to her work. A devoted animal lover, Patty supports various animal welfare organizations and is fluent in Cantonese, plays classical piano, practices yoga, and enjoys eating. And I'd just like to thank Patty very much for volunteering her time today to be here with us. So I am going to turn it over to you, and you can start your presentation.
Thank you, Matt. So good morning, everyone. Thank you for joining us today. As Matt has indicated, I'm a lawyer with the law firm of Bishop and MacKenzie. I practice in the areas of wills and estates. I do have a primary focus on the estate litigation side of things. So today's seminar on handling disputes, well, disputes are all I see in my practice. So what I hope to do today is to share some information with you so that when you walk away from this seminar, you will have a better understanding as to the types of disputes that an administrator of an estate might see out there, some ideas as to how you may be able to handle, manage, or resolve disputes, as well as you may have some additional questions that the seminar may have given rise to, and that's the whole point of it. It's to give you some information so that you can start thinking or asking the right questions of the right people when it comes to disputes in the administration of an estate. Now, most of you here are likely here because you are either someone who is already administering an estate, so an executor or an administrator or a personal representative, or you know you've been named as an executor, or you know you will be administering someone's estate in the future, and so you're getting the head start on it to try to get a better understanding of what you might be up against. Or you might be someone who is actually in planning stages of your estate, and again, you want to get a better understanding as to what might be out there for your executor in the future for planning purposes. So again, hopefully what the seminar will do is provide you with some information, and so that you can start asking those questions and thinking about the right things in order to plan properly or to be able to handle what you are dealing with right now. So before we start, next slide. You don't mind, Matt? There we go. First things first, again, this is legal information. It is that I am providing for you today. It's not legal advice. It doesn't replace the need for legal counsel and advice for your specific situation, for the things that which may arise in your circumstances. So while you may take some information away from this course or this seminar, you should always consider, especially if you already are administering an estate and you're looking at a set of potential conflicts or disputes, I do highly recommend that you speak to legal counsel and seek some legal advice specific to your situation. Now, you can speak to any legal counsel who has the expertise in this area. You do not have to just call me, although if you want to give me a call at any time to ask the questions to see what your situation is, I welcome that as well. But I think it is important, especially if you're dealing with a dispute already or know there will be a dispute, that you get that help early on, sooner rather than later. And we'll discuss a little bit, go into details about that a little bit more. Now, another thing you should keep in mind as well is that the advice, or rather the information it is that we are sharing today, is specific to the province of Alberta. So if there are any assets that are outside of Alberta, or you're dealing with an estate or people outside of Alberta, you may actually need to seek legal advice in that other jurisdiction. So while the different provinces across Canada have similar laws, there are different laws in each province, and so each province handles certain types of issues or certain types of disputes in a different manner than Alberta. So again, if there is something that's outside the jurisdiction of Alberta, you will want to seek legal advice specific to that area. And if you're dealing with something that is outside of Canada, so in United States or overseas, absolutely you should also seek legal advice in that specific jurisdiction, because the laws there can be wildly different than what it is that we're used to seeing in Canada and in Alberta. Okay. Next slide, please, Matt. So just a brief kind of basic foundation, a little bit of a discussion about the role of the personal representative. Now, I don't plan to go into this in detail. It's just to give us a little bit of a foundation and the basics of talking about disputes as we go further on. But as Matt has mentioned, we have actually a number of seminars that have either taken place or will take place as part of this Estate Administration Week. And there is a very specific webinar on the role of the personal representative. So if this is a topic you want to go into more detail about, I definitely recommend that you check out that particular webinar, okay? So first things first, some terminology. You are probably most familiar with the term executor. And what an executor is the person who is appointed by will to act as the administrator of an estate, the person who's going to administer the estate. An administrator plays the same role, but this is someone who is appointed by court order because there either isn't a will, so there is no will appointing an executor, or the will is somehow either deficient in appointing an executor, or maybe the executors who were appointed did not want to be an executor. So if someone has to apply to a court to be granted the role of an administrator, we call that person an administrator. Now, in Alberta, we use the terminology personal representative. to kind of talk about all of these people, whether you're appointed by will as an executor, whether you apply to a court to be appointed an administrator. We call all of these people personal representatives. So for the purposes of this particular webinar today, I'll be using those terms interchangeably, and you'll probably hear me say PR a lot as well, just as a shortened form of the personal representative. But in essence, we're all talking about the same person, the person who is responsible for administering the estate in accordance with the will, if there is one, and the laws of Alberta. Okay, so that's a PR, executor, administrator. We're all talking about the same thing. So a PR essentially steps into the shoes of the person who is deceased. It's a very big job. So if you are finding yourself in the position of a PR, those are not easy shoes to fill. Some things to keep in mind before we go into the dispute part of it is, first of all, as a PR, an executor, administrator, you are stepping into those shoes. Nothing more, nothing less. Okay, so if we're thinking about conflicts, certain disputes which may arise, you are wearing the hat of the person in the estate role. You do not take on more than what that deceased person has or doesn't have, and you don't take on less of it. So a primary example of that is, and I get asked this often, is if I step into the shoes as an executor and the deceased owed a whole bunch of money to a bunch of people, do I then become personally responsible for it? The short answer to that, absent some very special circumstances, is no. You are only stepping into the shoes of the deceased. So if the deceased owes a bunch of money to people and doesn't have enough money in the estate to pay it back, you as the executor don't have to, go into your own pocket to pay it back. You only deal with the debts and the assets that are there. Okay, so you're stepping into those particular shoes, nothing more, nothing less. It's also very important for you to understand what your role and responsibilities are as a personal representative. Generally speaking, as a PR, you are in charge of administering the estate in a fair, reasonable manner in accordance with the will and the laws. So you have a certain obligation in that respect. You also have certain obligations in respect of the beneficiaries to, again, do everything properly in accordance with the will and also treat the beneficiaries in a fair manner, and you owe them certain duties and responsibilities in that respect. So you always have to keep that in mind when you're in this role. You're balancing a lot of things, but you are not acting for yourself, you're acting for the estate, and you do owe certain duties and responsibilities towards the beneficiaries and the interested parties in the estate. So to that end, as a PR, generally very good practice to keep very good notes, very good records of what it is that you are doing, have done, whether it be in terms of an accounting, so the monies that have gone in and out of the estate, or even in respect of, as we're talking about the disputes, the steps that you have taken and things like that, because ultimately at the end of the day, you have to answer to the interested parties, to the beneficiaries of the estate as to what you did with the estate. So you want to have good records to be able to show these people what it is that you've done, and that the job that you've done was done in a fair and reasonable manner. Okay, so some of the general principles you want to keep in mind in your role as a PR overall. Next slide. And so just to give you a little bit of an idea as to what specific things you may be facing as a PR, and again, these are just examples. There are a number of different things that you may have to deal with when you step into these shoes, but just some of the general, more common things. For example, you would be responsible for the funeral and burial arrangements, okay? You will also be the person who has to determine, figure out, and also manage all of the estate's assets and liabilities. You will make decisions, or you will have to actually take the steps to do it, as to whether you apply for a grant of probate or a grant of administration. Again, those are topics in and of itself. So if you're curious as to what the details of those are, or what considerations you take into account, there's some other webinars that you may very much so want to check out. Of course, there are, things like what we're going to talk about today. You will be the person who will be handling and managing conflicts and disputes that arise in the context of this estate. And that may go hand in hand with things like seeking court advice and direction or going into litigation, although those are not the only options there. And that's what we're going to have a bit of a chat about today as well. But you will be the person who deals with all of those things. And of course, at the end of the day, when everything is done and over with, everything's been settled, you have all of the assets, paid off all of the liabilities, and there's monies left over, you will also be the person who's responsible for estate distribution. Okay. So if we go to the next slide. Now we'll start talking a bit about the topics that we're all here for today, disputes and conflicts. Now, to understand how it is and to think about what you do in terms of handling these disputes, the first thing that you need to be aware of and need to start thinking about are the types of disputes that you might come up against. And again, this is what I do for a living in my practice. So this is all I see in a day in, day out basis. But there's a number of different types of disputes that you will come up against. So this isn't an exhaustive list of it, but these are just a general idea as to types of conflicts that you may see as a PR. The first type, what I have up here, the validity of the will, the challenges to the validity of the will. This is actually a really interesting category of dispute, because what we're talking about here is people who you might see a challenge as to whether someone thinks a will is valid, or you might see a challenge when it comes to the grant of probate or administration if you apply for that, and someone might challenge whether probate should be granted or whether administration should be granted. These two types of challenges actually puts the PR in an awkward position because they are challenging the authority of who should be the personal representative and putting that into question before everything even starts. These types of questions and these types of challenges tend to come at the very start of the administration of the estate. So, for example, when we're looking at challenges to the validity of the will, you may have right at the start, you think you're acting as the executor, you have a will in front of you and it says you've been appointed as an executor. And so you go, okay, great, I'm the executor. I have to start making all of these decisions and start handling all of these things. But then someone pops up and says, you know what, I don't think the testator, so the person who died and made the will, I don't think that person actually has had the capacity to make that will. At that point in time. So I don't think that's actually a valid will. That type of challenge, you will see how it challenges your authority. You're acting pursuant to the will that appoints you as an executor. And then here is someone who's saying, no, I don't think that's a valid will because that person didn't have capacity. So these types of challenges do tend to put you as the PR in a bit of a awkward situation because someone is actually challenging your authority and your role in that area. So when there are these types of challenges, you're often in this gray area where you are kind of the executor and kind of not, and you're kind of navigating, the underlying currents of that. So these types of initial challenges will put you into an awkward position, but they are, it's not that they're super common, but they are one of the major forms of challenges that we see when it comes to, for example, litigation, the stuff that I do. People that go to court over it, we're fighting about whether that person had capacity at a particular point in time to make that will, or things like, if you find multiple copies of wills, people might say, well, you know what, this is the valid will, this one isn't. And again, it might come to things like whether someone had capacity. It might come to situations where they say, hey, I don't think this will was executed properly, this isn't a valid will, things like that. We do have certain webinars again on issues like capacity to make a will. So again, check that out if that's an issue that you think you might be dealing with. In terms of, when you're talking about challenges to the grant of probate or administration, and we'll get into this a little bit more. When you die without a will, the person who gets to administer your estate is actually set by law. So our legislation has a number of people that it lists out. You know, if you don't have a will and you have no executor that you've named as the person you want to administer the estate, here are the here are the people who have the ability to apply to become an administrator. And usually it goes in the order like in a family order type situation. You a surviving spouse, children. If there are no children, it goes down a list like that. So when you don't have a will and people don't know who the appointed executor is, and someone steps up to the plate and says, I want to apply to become an administrator of this estate, there are sometimes challenges to that as well, right? People might fight about who like there might be different people who wants to administer the estate, sometimes all with equal standing. So for example, think about, if you have a number of children, adult children who are all in kind of equal standing to apply to become an administrator. And they all want to be administrator, but they don't get along with each other, so they don't want to act together. They want to exclude one person versus another. You see that type of fight as well in terms of the grant of probate or administration. So again, these types of categories are challenges that tend to come right at the beginning of the administration process and tends to throw into question as to who the administrator or who the executor should be, challenges that a little bit. So it is a little bit of a gray area if you are the person who is acting as or purporting or thinking that you are the personal representative or the person who should be administering this estate. Okay. Now, there's also what I categorize as internal conflicts, family type disputes. And these might be viewed as perhaps more minor type of disputes, but I never discount the importance they are of people, like the importance of it is to people. So, for example, most of the time when people, even if they leave a will, they will not set out an exhaustive list of all of their personal belongings and who it should go to, all the things that are in the house, the clothes, the furniture, the TV, the dining set, the china. A lot of the times that's left to the executor or the PR to do what they think is appropriate according to the will and the law. And so you might see things like fights amongst family members breaking out because somebody wants the china set and someone else also wants the china set, and they might have equal claim or whatnot to it. So you might see conflicts like that come up that are perhaps not court-worthy, or although we've seen fights in courts about that as well. But those types of conflicts are what I classify as internal conflicts, things which you see almost as family fights on a day-to-day basis while people are alive as well, where perhaps you don't require the intervention of a court or a lawyer or whatnot, but are nonetheless issues that you as a personal representative will need to deal with in order to properly administer the estate and finish administering the estate. And then the last category, again, just general categories here, I've lumped all together, and probably this is the area that you are all thinking of when you signed up for this webinar: claims on behalf of or against the estate. The types of claims where you are dealing with third parties, where you are looking at potentially going to court on or having to bring in mediators or dispute resolution, where the conflict is more serious, or you're already in the midst of some sort of dispute or litigation, or you're really headed that way. Those, again, that's probably going to be one of the primary focuses of this webinar as well. So we'll get into a bit more details of that as well. Okay. So if we can just go to the next slide here. Now I'm going to, again, talk a little bit more about the claims on behalf of, either on behalf of or against the estate. And again, when I'm talking about these, we're talking about the more, what we may think of as more serious type claims, where we're looking at potential litigation, potential court disputes, things that are really blowing up, things that you can't have a sit down about, or maybe you can, but just some of the more bigger issues that we're talking about. And so we're going to dive into that a little bit. But before we go there, I see that there are a number of questions that have popped up already. Matt, I don't know if if there are any questions that you think may be appropriate to answer at this juncture, so that everyone has a good foundation or base going forward, or if it's things that we might want to put over to the end of the session for the Q&A.
Yeah, so some of them more than likely can probably wait a little bit. But as I just roll through here, there was one question about grant of administration or grant of probate. So I think that's appropriate to bring up.
Sure.
Can you apply for a grant of administration before the person dies, knowing that there is no will?
The answer is no. So all of these only come into play after the person has passed away. Yeah.
Okay. And then a lot of them we can probably save for a little bit, but I will ask this one in the chat just so I don't miss it, since I'm going back and forth between chat and Q&A.
Sure.
If you don't have a will, does everything automatically go to the spouse, or does the spouse have to file a form to become an administrator? If so, where do you get that form?
That's actually a multi-layered question with answers to different parts of it. Generally speaking, if someone passes away without a will, like I had mentioned before, we have legislation which then sets out what happens. It will set out who has the right to apply to be an administrator and administer the estate. And it will also set out how, generally speaking, an estate is distributed. So the answer to whether it goes automatically to a spouse, it's situation specific, because the legislation will take into account various factors when they determine how the estate should be distributed. Things like whether there is, any surviving children is one of the factors that will be taken into consideration. Like if there are kids from that particular marriage, then the estate is distributed in a particular fashion. If there are, for example, kids from a previous marriage, an estate, and now there's an existing spouse, but they're not the parents to those kids or biological parents to those kids, the legislation will say that the estate is then distributed in another manner. Depending on the size of the estate, there are some threshold amounts that come into play as well as to how the estate is distributed. So I can't answer that question with any kind of definitive, just because there are a number of different factors that come into play that affects, how the legislation looks at the estate distribution. But there is legislation out there, depending on the situation, will set out how it is that an estate should be distributed. And then in terms of forms, and whether things just automatically roll over, we'll actually talk about that a little bit, which might give you a bit more information in that respect. But it will depend on what those assets are and how those assets were held as to whether it kind of automatically rolls over or not. And then, of course, that will depend on whether there are any forms or transfers or procedures that you need to go through in order to get certain assets into certain people's names. And when it comes to applying for a grant of probate or grant of administration, that's actually a court process, what we call generally speaking, a desk application, where we fill out a number of forms and submit them to the court in order to be granted either probate or administration. And of course, if you have if there is no will, then it's a grant of administration. So those forms can be filled up for the grant of administration purposes. You can obtain them from a number of different sources. Queen's Printer is one of those, but again, that's just talking about the grant of administration and the application for it. There are, again, depending on the assets, depending on the situation, depending on what types of things that you're talking about, there might be a number of different other forms or processes that you're dealing with to get certain assets into certain people's names. Okay. Great.
So I'll turn it back over to you. We can save more of these questions for later in the presentation.
Perfect. So we're back to talking about the types of disputes, and now I'm going to focus on the claims that we might see either on behalf of the estate or against the estate. So what you'll appreciate, of course, is I think maybe when you're sitting here, you're thinking of acting as a PR, or you are acting as a PR, you might think of, all the claims that might come my way, all the different types of disputes that I might have to deal with. That's what I want to focus on. But what you also have to remember is sitting as a PR, you have a duty to look at what the potential assets of the estate are as well. So what you will also have to look at is you may be in a situation where you are the person who is bringing a claim on behalf of the estate. So not necessarily just, fielding or dealing with claims that are thrown your way. You may actually have to take some active measures to bring a claim on behalf of the estate. Now, a lot of these types of claims are kind of, two sides of the same coin, right? So sometimes you're the one who's bringing an active claim for the exact same issue that someone else might at another time bring against the estate. So we'll just talk about those different types a little bit. First types of claims here were existing claims, okay? Such as, again, if you're sitting at claims that you may need to bring on behalf of the estate as a PR, such as monies that are owing to the estate, okay? So if we go back to the base concept of when you are a PR, you step into the shoes of the deceased. That deceased person might have existing claims either for or against people that don't just disappear because they've passed away, right? As much as we would like to think, well, you know what, if we die, all of, for example, the debts that we owe to people go away. They don't. They all are still there. It's just that instead of the deceased handling it, you now have a PR, who is dealing with the situation. So all of those existing claims before the person died, for the most part, still come into play and are still at play when that person does die and a PR steps into the shoes of that deceased person. So you will have to deal with all of those claims as a PR. And these existing claims may be things like I said, money's owing to the deceased. And you as a PR will then have an obligation to look at that situation and say, I need to go and get that money. What should I do to go get that money? So, if the deceased has gone and lent money to someone and, there's $10,000 out there outstanding from that person, you as a PR might say, okay, well, I need to do something to go get that money back because that's part of my obligation to collect the assets of the estate, right? You might see other existing claims which are a bit more complicated and more complex. For example, if the deceased had gotten into a motor vehicle accident, a car accident, before passing away, and they have a very valid claim against the person who was driving the other car and the other person was at fault and they should be able to get some money from that, you may have to step into the shoes of that deceased and carry on that claim and work with the people who've been working with those on those claims, okay? You, as a PR, may also have to deal with proceedings related to previous relationships or common law relationships. And again, this stems from the fact that just because the deceased passed away doesn't mean issues or things that haven't been completed or dealt with just go away. So when I'm thinking proceedings related to previous relationships, for example, if the deceased person was in the middle of divorce proceedings and had matrimonial property claims before he or she passed away, those proceedings generally carry over for the PR to have to deal with. Now, divorce proceedings, once a person dies, obviously those two, the former husband and wife, are no longer married. And so, divorce proceedings are not something you generally have to continue, but matrimonial property proceedings is generally something that continues on and has to be dealt with if the deceased and his former spouse or her former spouse have not dealt with the split in matrimonial property. Those are types of claims that you as a PR may have to claim on behalf or carry on behalf of the estate. And also, it could be on the flip side. So it might be a claim that you would have to field because it's continued on by the other side, and you as a PR of that estate have to continue dealing with that. Now, common law relationships, it's actually an area that the issues arising from common law relationships, it's something that I see actually quite often, and we'll go into that a little bit as well. And it actually has kind of ramifications or implications for a number of different types of claims. But again, it stems from the relationships and the things that come out and continue on. Just because the deceased died doesn't make it doesn't go away, right? So you may continue to see disputes that arise from that, or at least issues or problems or things that you have to deal with arising from previous relationships, common law relationships, things like that. You may see, again, acting as a PR, a claim that you may have to bring on behalf of the estate when someone passes away. Insurance and benefits claims, right? If someone had a life insurance policy or had some benefits claims out there that at passing, you can then claim for, you would have that responsibility of dealing with this. Sometimes they go very smoothly. You fill out a form and everything just gets released to you. It's no problem whatsoever. And other times not so much. And you have to fight with people a little bit over that, okay? There are also a number of claims that arise in relation to assets that are held jointly, and it goes a little bit to some of those questions that were asked earlier. And again, we'll go into a bit more detail about that, but there are a number of disputes and litigation and matters that stem from assets that are held jointly by the deceased with other people. And again, we'll go into that topic a bit more. Let's go to the next screen here. And so on the flip side of that coin, the examples of claims where that might be against the estate, whereas a PR you're looking at fielding and having to deal with because it's thrown your way. As you can see, some of these things we've already talked about a bit, existing claims. So, you know, on one side, there might be claims or monies that you need to go after that are owed to the deceased. On the flip side of it, you may have claims that are owed by the deceased and you will have to deal with. The deceased might be in the middle of litigation because they owe someone money, or something might be going into foreclosure. You know, all of those claims and disputes and litigation continue on, and you as a PR will have to deal with it. Same thing with proceedings related to previous relationships, common law relationships. We talked about that on the flip side of that coin there. If there are going to be claims and issues and problems that arise from these types of previous relationships, and as a PR, you will be the person who has to deal with claims that are brought against the estate as a result of these types of relationships. Same thing with assets that are held jointly. There are a few things that arise, claims against the estate after a person passes away, which are a little bit more specific to just claims against. So for example, tax liabilities. Again, when someone passes away, there are certain tax liabilities that arise, and I'm not going to go into detail about this at all because it's an entire course in and of itself. And there are, again, some webinars arising from Estate Administration Week and even Wills Week that talk about what tax liabilities a potential estate can look to. And sometimes these claims, again, can be easily dealt with. You fill out a few forms and you pay the tax liabilities. Other times there might be much more involved processes that you need to deal with as an administrator. You know, if the estate gets audited, if there are some complicated business structure holdings, you know, those tax liability type issues that you will have to deal with may be a lot more complicated, might turn into disputes, may turn into litigation, may turn into, you know, some sort of CRA process that you have to go through, which feels like litigation. And so those are things that you will watch out for. You also then have, in addition to assets that are held jointly, when someone passes away, there are also certain categories of assets that can have designated beneficiaries associated with it. And, you know, things like life insurance policies, you can designate a beneficiary. There are some disputes that arise out of that as well. And we're seeing it as a more common litigation matter. And again, we'll go into that in a little bit more specific detail in just a little bit. Now, one category of thing that you are dealing with as a claim against the estate as a PR that's becoming very, very common. One of the major categories I would say that I see litigation is the family maintenance and support claims. And we'll go into, again, a bit more detail about these specific types of disputes in a few slides there. But generally speaking, when someone passes away, there's a category of what we call family members. It's under a piece of legislation where certain people under specific circumstances can make an additional claim against the estate. And so as a PR, if those categories of people make that particular claim, you will have to deal with it, okay? So next slide. And before I go on to, you know, I'm going to talk about some of those specific types of disputes a little bit more just because of how common they may be, or they're kind of like a rising tide in terms of the disputes that we see. But before I get to that point, Matt, are there any questions you think we should answer again from a foundational perspective? So if there's questions or clarifications that are needed.
Sure. So I see there was some common law questions that have been added to the Q&A, but I'm going to leave those because we're right at those slides right
Yeah.
now. And I think you're going to be able to answer quite a few of them.
Perfect.
Again, going back to some of the probate questions. So how can an executor find out if a grant of probate was even filed on behalf of the client?
Okay, so if you are an executor, you probably are the person who filed the grant of probate. But if for whatever reason you're not the one who did it, so maybe perhaps you're talking about a situation where you hired a lawyer to do it on your behalf, or maybe there's been a switch in executor and you don't know what happened in the past, things like that. A grant of probate is, the application itself is done through the courts. So you can do what we call a court search to find out if there has been a grant of probate. Now, what that does is it only tells you if there is a grant of probate. It doesn't necessarily tell you if it's been filed. Right now, our court system, because of COVID and various other factors, we're a little bit backed up. And so an application for a grant of probate, for example, might have been submitted, but it doesn't hit the system. So you when you do a court search, you don't see, applications submitted. All you'll see is whether an application has been granted or not. So if it hasn't been looked at yet, but it has been submitted, you might not necessarily be able to find that out. And right now, when we submit an application for a grant, it could be 2 or 3 months before we hear anything back. So in that time period, if you happen to ask the court in that 2 or 3 month period for a court search, you will see nothing. You will not see whether it's been submitted or not, and you will also not see whether it's been granted or not, because it's in that in-between time slot.
Okay, and sticking with some of the probate questions here, is a grant of probate required in Alberta regardless of the total value of the estate, or is there a minimum dollar amount before the PR is required by law to apply for the grant?
It's not a dollar amount. Rather, it's dictated, usually the decision to apply for a grant of probate is dictated by the type of assets that you have or the estate has. The most common reason someone applies for a grant of probate is if there's some kind of real property, houses, that is in the deceased's name alone. You absolutely require probate in order to deal with land titles. So it's more determined by the category of assets rather than the dollar amount of that particular estate.
Okay. And rolling with that then, can a house be put up for sale before a grant of probate? If a house sells quickly before the grant of probate, what can the executor and the beneficiaries do to expedite so as not to lose the sale?
You can apply to courts for an expedited grant in certain circumstances if the situation warrants it. You can put up a house for sale before grant, but then what you have is a risk factor that, the situation where you're in where you don't have a grant yet and you can't actually change title, but you've gone and sold the house. So you need to be comfortable with that risk factor and be able to build in certain mitigation strategies if that's what it is that you're going to do.
Okay, so I'll turn it back over to you and you can continue.
Perfect. Okay, so we are kind of drilling down on the types of disputes that we're talking about here. And one of the types of disputes or issues that we want to focus on is common law relationships. And again, it's because it's something that I'm seeing more and more common. It's coming up more and more often. So something that we should all give it a little bit more thought on. So the existence of a common law relationship will actually impact other claims. So if you think about it, for example, when I talk about the grant of administration, how there's a category of people who can apply to be an administrator if there is no will setting out an executor. Well, that list will, at the very top of it, the person who can apply will be a surviving spouse or common law partner. Okay, so again, right off the top, at the top of the list there, we are talking about people, who can apply to be an administrator. So if there's a finding of a common law spouse, then that person can go ahead and apply to be an administrator. So it has impact in that area. You'll also see that there's impact on things like family maintenance and support claims. So the fight about who is in a common law relationship does come up more and more often now. And part of that is because we're an evolving society. There's more and more people who don't get married. And so there isn't that piece of paper that defines that relationship. And for the most part, most of us know when someone has a common law spouse, but sometimes you'll be surprised at the lengths people go through to actually hide that from their family members. And there's tons of war stories about that. We actually, again, under Estate Administration Week, there's, I think, a webinar just right after in the next few days that are these war stories about, estate administration things and common law relationships, and the fight about who is in a common law relationship come up more often than you think. So if you're interested in stories like that, by all means, please check that out. Now, the definition of a common law relationship kind of depends on what the situation you're dealing with is. So generally speaking, we in Alberta actually have an act that defines what a common law relationship is. And we actually call common law relationships adult interdependent partners, or AIPs for short, AIP. So you actually hear lawyers in this area talking about AIPs a lot. We're talking about adult interdependent partnerships. And that definition, again, depends on the situation. But generally, we're talking about people who have been in an interdependent relationship for 3 years or more. It changes if you have a child together. It changes if you have certain types of agreements that you signed together. So again, it's a bit of a fluid definition, but we do have legislation which sets out what a common law relationship is. Now, depending on what you're dealing with, there are other statutes and other legislation which may come into play. So for example, if you're looking at income taxes, the Income Tax Act actually has a different definition of what a common law relationship is. If you're looking at pensions, pension acts have a slightly different definition of what they call a pension partner. So again, depending on the type of asset or the type of situation that you're dealing with, you may have to be looking at a different piece of legislation with a slightly different type of relationship or definition, which is why sometimes you hear different definitions, right? So, but generally speaking, in Alberta, we're governed by this one statute, and we call our common law partners AIPs. Now, the determination of whether, like I said, someone is a common law partner can be very situation specific. And, a lot of the times, again, while it would be lovely where everybody says, hey, I've lived with someone for 3 years, we're definitely in a romantic relationship, we shared all of our finances, there's no questions that we're a common law relationship. Usually those are not the situations that we see in my office in court, right? Because they're a little bit more clear cut. But there are a lot of situations where it's not defined. And people, like I said, go through great lengths to perhaps hide or minimize the relationship that they have with a particular person. So when that person dies, someone else all of a sudden steps up to the plate and says, I'm in a common law relationship with this person. I should have the same rights as a surviving spouse, and then chaos ensues. Examples of that, we've in our case law kind of arsenal, there've been situations where, for example, we've seen older people, well onto their second or third marriages, have adult children, they're like 65, 70 years old, snowbirds. And they go to Florida for half a year every year. They live in Florida for half a year and they come back to Alberta for half a year. Well, lo and behold, they meet someone and they go to Florida and live together in Florida for half a year. So while they're in Florida as snowbirds, they're living together. These two grown old adults who know what they're doing. They come back to Edmonton, and for whatever reason, for various factors, they don't want to let their grown kids, their grandchildren, their existing family know that they're actually in this relationship with this other person, right? And there's personal circumstances that play into that. So they never tell any of their family members in Edmonton that, hey, I lived together with someone for half a year and we're in all intents and purposes living together as, a married couple in Florida for half a year. Tells nobody. One person dies and all of a sudden the other person that they've been living together in Florida steps up and goes, you know what, I was actually in a common law relationship with your dad, or mom, or whatever happens to be. And of course, the children, the grandkids, never heard about this. Don't believe it. Get up in arms about it. Litigation ensues. And so then we all have to go into these factors and look, well, what is a shared home? Is it enough that they go live in Florida for half a year? Are they sharing a home? Is that enough? Do they have children together? Well, no, not in this situation, and they never told anyone about it. Do they have some kind of financial interdependence? How did their assets play out? You know, who contributed to what? Who paid for what? Were they completely separate or were they completely intertwined? Social interactions, you know, what did they tell people? Certainly they told no one in Edmonton, but what about the people in Florida? Did they go out and socialize as a couple, and everybody in Florida who lived in that community that they were in know them as a couple and thought they were married and whatnot? What did they tell other people? All of these factors come into play, and this is what it is that we fight about, okay? So that's what happens when there are common law relationships or allegations of common law relationships that, you know, not everybody knows about. Okay, and again, there are ramifications as to a finding of a common law relationship. So it's important to keep those, you know, to keep that in mind. So the next kind of category of disputes that we want to look at into and come up very often now, quite common now, are the assets that are held jointly or assets that have designated beneficiaries. Examples of assets which may be held jointly: homes, real estate, and that's very common. Most people out there probably hold their home in connection with, for example, their spouse. Same thing, bank accounts. Those are the most common types of categories of assets where they can be held jointly as joint tenants. There are also assets that maybe we think of a little bit less often that have designated beneficiaries: life insurance policies, RSPs, RIFs, TFSAs, pension plans, okay? When you have assets that are held jointly, generally speaking, at least in terms of what we call legal title on paper, when one person passes away, that asset passes by way of survivorship automatically to the surviving person, that surviving tenant. And when it comes to assets with designated beneficiaries, you know, people, when that person dies, then that category, that life insurance policy, that pension plan, the benefit of that goes to that designated beneficiary. However, we in law also have a concept called beneficial interest. So we have legal interest, you know, what passes on paper, what, you know, whose name it is in on paper. And then there is the beneficial interest aspect of it, where we talk about, well, who should actually get the benefit of it? And that brings into concepts of trust. I think the easiest way to understand that from most people's perspective is if you hold something in trust for someone. So for example, you have a bank account that you hold in trust for your dad. The money in it might be in your name legally on the bank account, but you know that the benefit of it, who actually owns it or who should use that money is, for example, your dad. That's what we're talking about when we're saying legal versus beneficial interest. A lot of the times when you own something, both of those things match up. It's in your name and it's for your benefit. But occasionally when you hold things in trust for people, for example, the legal title would be in one person's name, but the benefit of that asset goes to that other person. So there are fights that arise from that upon death because of assets that are held jointly or with designated beneficiaries. Commonly, when you're dealing with assets that are held jointly, so if you hold an asset jointly with a surviving spouse, so if you and your wife or you and your husband hold your house, for example, and you're joint tenants and both of your names are entitled as joint tenants, then if one person passes away, then obviously on legal title, by way of survivorship, the surviving spouse gets that asset. And what we have in law is we have a presumption that the person who passed away meant to gift whatever interest he had, that survivorship interest, gift it to their surviving spouse because it only makes sense. It's common sense for us to say we want to pass on that asset to our surviving spouse. So usually when you have assets that are held jointly with their surviving spouse, it doesn't cause a lot of, usually that's not where the fight is, because everybody recognizes, hey, you held your house jointly with your wife, you die, you give your house wholly in every respect to your wife. That makes perfect sense. Okay, that's not usually where the fights are. Usually where the fights are with assets that are held jointly with your adult children. Okay, the reason for that is because lots of times, if you really think about it, when you have an adult parent and an adult child, and that adult parent puts an asset into joint names with that adult child, and that child never paid for it, it wasn't like a joint venture of some sort where someone went and said, hey, well, let's go buy a house together or whatnot. That adult parent often puts things into joint names for various reasons, not necessarily to gift it to that particular adult, or at least enough for us to doubt it. If you think of bank accounts, for example, how many times have you heard of a dad saying, oh, you know what, son, I don't want to do banking anymore. I don't want to go to the bank. It's a pain in the ass. Why don't you go do things for me? And you know what, to make it easier for you, I am going to have, why don't you just, I'll put your name onto the bank account. That way you have authority to go help me like deposit this and take out this and write checks for this and do a bank draft for this, do my daily banking. Let's do that. The dad put the son's name on title to that bank account for convenience so that he can access the bank account. The question remains, did he meant to give that money to that child if he dies? We don't know that, right? It's not as clear cut as with a wife where you spent your lifetime building your life and your asset base together, so it makes sense for you to just gift it over when you pass away. Less clear with adult children. So in law, what we actually have is there is a presumption that if there is an asset that was put in joint names with an adult child for no particular consideration, right? Like, again, nobody bought things together, nobody put money, like the adult child didn't put money into it as well, but just was simply put into joint names without consideration, then our presumption in law is actually that the deceased, so the dad, does not mean to gift that particular asset over to the child when they die, but rather that the adult child holds it in trust for the estate when the parent dies. That's actually our presumption. Now, this is just a presumption in law and can be rebutted in a number of ways. So if dad, writes in his will, says, I have a bank account that is held with son at this bank, here's the account number. When I die, whatever money is left over in that bank account, I do intend to have my son keep it, then no problems. You've rebutted this presumption because dad made his intentions and wishes very clear. But absent some sort of indication of what dad's intentions were, the presumption is actually the exact opposite, that it wasn't meant to be given to son. Son holds it in trust for the estate, and it gets dealt with in accordance with the will or the law. Okay. So similar issues, if we go to the next slide, arise in respect of assets with a designated beneficiary. The same arguments apply. Again, usually the issue only arises if that designated beneficiary is an adult child. So in certain circumstances, again, a deceased puts an adult child down as a designated beneficiary under a life insurance policy. And let's say that adult child happens to also be the executor of his will. Sometimes people will come up, other siblings, other beneficiaries, and say, you know what? I don't think dad intended to designate that child to have that money outright. I think that child was actually designated because they're also the executor. So, dad meant to give that life insurance policy proceeds to that child as executor to be held in trust for the estate. So it gets dealt with according to the will. So this type of argument is a little bit less common, but it's the same type of considerations as with joint assets can arise in that in these types of scenario. So again, something to be aware of in terms of the fights that come up. So again, usually what happens is you either have these types of assets that are held jointly, or you have these kind of designated beneficiary type situations, and you will have another beneficiary, another sibling who looks at the situation and goes, no. That's not what dad intended. He might have put that bank account or that house in joint names with you, brother, but it was because he wanted you to administer it. He didn't mean for you to have it. He maybe wanted you to help with the banking, with some of his like day-to-day things, but that money he intended to divide amongst all of us equally. Those are where the fights are. And then we go to court and we fight. We have to look at what, that presumption, right? And look at whether it could be rebutted, whether dad has said anything to anyone at any point in time indicating who he meant to leave that bank account to, or who he meant to leave that house to, or whether he had written down in his diary somewhere, what it is that he wanted done with that, or whether he has written down in his will, which would make it really easy for us to determine what his intention were. So the fights in this area are usually around how to establish what that parent's intentions were, so that we can either rebut or confirm that presumption that that adult child is actually holding a trust. Okay. So I know this was usually, these are more hot topic type questions. Are there any questions that we think should be answered at this moment, or do we wait until the Q&A at the end, Matt?
So I think you're pretty close to being done. I think there's only a few more slides, right? So we can probably just hold off and keep powering through if you're okay with that.
Yep, sounds good. So, and then that leads us to the last category that I want to just delve into a little bit more deeply. Is the family maintenance and support claims that can be brought against an estate after someone passes away. This is a claim that is given by way of statute, so it's according to a piece of legislation out there. So if you are considered considered a family member by definition of this legislation, you have the ability to bring a claim against the estate for additional support if the deceased did not provide for you adequately. I think that the terminology family member is super confusing because we generally refer to family as family members. So we're not talking about just the broad general category of family. Family member is very specifically defined in the legislation. It includes a surviving spouse or an adult interdependent partner from a common law relationship. It includes minor children. It includes children who are 18 to 22 who are in school, and because they are in school, unable to be discharged from their parents' care. It includes adult children who are, by virtue of a disability, unable to earn a livelihood. And it also includes, if you happen to be a grandparent who have been acting as the primary, that primary parent figure in a grandchild's life, that grandchild can also be considered a family member. So if you look at all of those definitions, what the legislation defines a family member as is essentially someone who would be dependent on the deceased. So if someone passes away and they have dependents, someone that they should be taking care of kind of by our broad societal type norms, then that person as a family member, if the deceased did not provide for them adequately in their will, so if they cut them out of the will or only gave them a small portion of the will, that family member can bring an additional claim against the estate for additional support. And so as a PR, you would be dealing with these types of for short, FMS claims. And again, these FMS claims are becoming more and more common. We do see them quite often. Part of it, usually at the very start of it, is a fight as to who is a family member. That's usually the first category of fight that we see. And usually it arises from things like common law relationships, where someone comes forward and says, I am an APE, I'm an adult interdependent partner of this particular person who passed away, therefore I'm a family member. So usually we see a fight there, or at least some issues there as to who that family member is, whether they fall under that category of family member. And then the second part of the fight that we usually see is whether there was adequate support provided, whether that particular family member, just because you can bring a claim doesn't mean you'll ultimately be successful at the claim, right? You still need to establish that the deceased did not provide for adequate care. And, as you look at that and that family member has to establish how much care they need, right? Essentially how much money they need on a day-to-day basis to survive, how long their life expectancy is. We have all sorts of stats about that. And then you come up with a number as to what reasonable support would be considered. And you also look at factors such as that family member's individual abilities, whether they have a whole bunch of assets, whether they have the ability, like they earn their own livelihood, for example, they make a good living, maybe they don't need any additional support because they support their own, they can support themselves. All of those things come into play, and that's usually where the second category of fight comes in, is if someone establishes as a family member, they bring a claim, they still need to be able to establish whether there was adequate support provided, and that's dependent on a number of factors such as what their personal situation is, before we can determine whether the family member is entitled to any kind of additional support from the claim or from the estate. So that brings us to the last few slides here, where now that we know about the different categories and the different types of disputes that a particular estate might face, and particularly a PR might face, then we start looking at how to either avoid, mitigate, or manage these types of disputes. First and foremost, if you are able to plan in advance and address the issues before death, that is actually the most ideal situation. So if there are any of you out there who, again, are in the position where you've been appointed PR, under someone's will, let's say mom and dad's will, mom and dad hasn't passed away yet, you're just kind of getting ahead of the game. Or if you're someone who's planning your estate and you're taking this webinar just to kind of understand what the hotspots are and what you might have to watch out for, then you will want to pay very close attention to this plan in advance estate planning type situation. Because that's the most effective way to mitigate, minimize, or avoid these types of disputes that we're talking about. What you will want to do is, as soon as you can, sooner rather than later, seek the appropriate type of advice for a particular situation. So if coming out of this webinar, you go, you know what, I see a few spots here where there could be potential disputes. I didn't realize it before. Maybe I have all of these assets held jointly with my child, or you as a potential PR knows that you have all of these assets held jointly with mom and dad. Seek some advice, right? Whether it be from a lawyer, an accountant, a financial advisor, someone who deals with these types of categories, talk to them, see if there is truly a potential issue or whether there's anything that you can do about it, okay? Be transparent about relationships. So here I'm in particularly thinking about these common law type relationships. A lot of the fights that we have in defining common law for people could very much so either be avoided or at least, so it doesn't get to the point where you're actually coming to me and saying, we're going to court, there's big potential for litigation, we're filing all sorts of things, is if while someone is alive, you go ahead and talk to them about the types of relationships that they have. If you think there's someone that you have a very serious relationship with someone, maybe you're living together, maybe you're not, because again, it's fluid as to, that's only one of the factors, a shared home, as to whether you have an adult interdependent relationship. Be transparent about those types of relationships with people, right? With your family members. Be honest with them about it. That will go a long ways to avoiding the fights later on down the road because of sheer surprise or people not believing it. Whereas if you voiced it very openly and told everyone about the relationship, if you had a relationship, perhaps there won't be a fight later on. People might not be happy about it, but maybe perhaps it won't be a court fight. Or, to the best of your ability, if there's someone who might be perceived as a common law partner, but maybe aren't, you might want to do something about that, right? You may be able to go to a lawyer and get things like what we call cohabitation agreements drafted up, where you set out exactly what it is that how you split up your assets and who's entitled to what, things like that. You may be able to mitigate that a bit. So be open and transparent and honest, both to like your family members and your friends, as well as to yourself and that other person, as to what type of relationship you have with that person. And I think what's really important too is that the person that is designated as the PR, especially like if you're going to do a will, is aware and understands all of these issues, right? Again, not just the relationships, but just as a whole. If you hear some of these hot topic type disputes, these little trigger points, and you go, oh, I might have that issue there. at the very least, make sure your PR is aware of that, right? So again, if you're in a situation where you're in the estate planning stages, where you are, you've been appointed PR, but mom and dad are still alive, have a talk with them about it, right? Try to get an understanding of what the estate actually looks like, so no one's surprised when that person actually passes away. So you might say, okay, well, this house that you're living in right now, whose name is it under? Is it under, mom and dad? Is it under both of your names? Or if only dad is left, oh, well, dad, is it under your name? Or, do you hold it jointly? You might say, well, I hold it jointly with sister A. Ask that question. Well, you hold it jointly with sister A for what reason, right? And he might say, oh, for tax purposes. Oh, I don't want to get probate. I've heard that and this happens a lot. I heard if you hold things jointly with people, you don't need to get probate. So I want to avoid probate. Go further and ask that question. Well, do you intend when you die that asset goes to sister A free and clear, or were you just intending that it forms part of your estate? And if the answer is, yep, it goes free and clear to sister A, well, then do something about that, right? Make sure that intention is well known, whether you're like the person who writing the will or whatnot. Like I said, put it in your will. This house goes to so-and-so by way of survivorship. I intend for them to have it. Period. Or put it down on a piece of paper somewhere. Go call your lawyer and say, I need something like this added in. I need to put down somewhere. Or have a family meeting where you tell everybody that's what the intention is. Or if the intention is the opposite, no, it's part of the estate. She only holds it in trust for me. It's meant to be split between the 4 siblings. Say that out loud. Put it down in writing somewhere. Put it down in your will if you can, so that there's no mistakes and misunderstandings about that when that person does pass away. Okay, so number one most effective method of dealing with this is before that particular person dies, before death, that these issues be thought about, addressed in the best, again, looked after before death. Okay, now next slide. If you're in a situation where you're already a PR, where you're administering an estate, the person has already passed away, and these options are arising, these things are disputes are arising after death. And obviously we don't have the luxury of saying, hey, plan it out, see if we can mitigate all of these. Well, there are still a number of things that you can do, or what you generally have to deal with in terms of managing and dealing with these types of disputes. Again, the advice that you go seek appropriate advice still stands under all of these circumstances, before, after death, if these disputes arise, even if the dispute hasn't arisen and you think that maybe it will because you've seen some of the documents. Seek that advice. Go talk to your lawyer, go talk to your accountant to A, get a better understanding of the situation, B, get an assessment from a legal perspective or whatnot, depending on what the tax perspective as to what the situation is and how you can handle it. And so you know what the issues are. So that always stands. Go seek appropriate advice, whether from whichever professional is more suited for that particular area. Just because I'm a litigator and I talk about going to court doesn't actually mean you always go to court over these disputes. It's entirely possible that you can resolve issues internally, right? By way of discussion between the various interested parties, whether it be the different executors who are involved, or the different beneficiaries who are involved. Sometimes a lot of the times, random family members will get involved, even if they don't have a particular stake in, they might not be a beneficiary, they might still get involved. You may be able to hold family meetings. As a PR, you tend to step into the shoes and start acting as some kind of ad hoc mediator or therapist or arbitrator a lot, and that just happens. So sometimes as a PR, that's what you have to do. You just step into the middle of it and try to resolve the issues yourself. It's entirely possible to go one step further and settle with agreement of all parties, right? So if you, for example, have a dispute about that house that dad held with sister A, and nobody, sister A goes, it's mine, and everyone goes, no, it should be the estates, and it's not clear what dad's intentions were. At the end of the day, if there are only 4 beneficiaries, the 4 siblings, those 4 siblings can agree to settle it out on their own. Sister A can go, you know what, fine, I can agree to give everyone, an equal share in it, just to settle it. I will not get mad at it. Or you can also agree to say, hey, I'll give you half of the value of it. The other half of the value goes to the siblings. You can agree to all sorts of different things if there is an agreement between the different parties. And again, mediating that agreement can be done internally by yourself as a PR. The more complicated the issue is, the more likely you will bring in a professional, whether it be a lawyer or whatnot. There's plenty of situations where people have come to me and said, you know what, I think we're going to court. And at the end of the day, after some, jaw clenching moments, we actually settle out of the court. About half of my cases get settled out of court because we can come to an agreement with all of the parties' agreement, even if it's not what the will said, or even if it's not what the paper work documents, you can still come to an agreement to avoid having to go that last step to court, which is what I generally see as is our last resort, is going to court through the litigation process. There are also some alternate dispute resolution type situations, mechanisms that you can access. Again, mediators, arbitrators, professionals who can step in and try to mediate the situation for you. So you can make use of those in all of these, right? Like whether you're looking to try to solve it internally, have some sort of formal settlement agreement, you can make use of these ADR type mechanisms. And like I said, last resort, you go to court, right? You can, if the parties can agree, we go to court to get the courts to decide it for us. Now, as almost like a final note, as the PR, what you often or can find yourself is in a potential conflict of interest whenever any type of these disputes arise. Normally, the executor is appointed, especially for the average Albertan family. The executor who is appointed usually is also a beneficiary, right? So usually it's one of the children, one of the adult children, one of four siblings who is appointed to the executor. So if we go back to these examples that we've been using, if there is a dispute as to whether sister A holds that house jointly with dad, and when dad passes away, whether he meant to give the house to her outright or whether she holds it in trust for the estate. There are four siblings. Let's say sibling B is appointed the executor. Well, you will see how the executor B, the PR, is actually like wearing very many different hats, right? On one hand, he's the executor with that overarching duty to act in accordance with the will, act in accordance with the law, and treat all beneficiaries and all interested parties in a fair, reasonable manner, and to kind of be neutral about it, right, as an executor. But on the flip side of it, you also have this executor who is a sibling who may or may not get along with sibling A who holds the house in title right now. And also a potential beneficiary. So if the estate is generally split amongst the four siblings, that executor B also has a financial or interest in whether that house stays with sister A or whether it goes back to the estate because it's being held in trust for the estate and split between the four siblings. So as the executor, as the PR, you actually, when situations like this, will often find yourselves in that potential conflict of interest where you're wearing more than one hat, and you have to be able to be even-handed in the way that you deal with things. And when when I act for an executor who is in that potential conflict of interest, several things can happen. Sometimes, again, we can settle it with all agreement of all parties and nobody has to step away or anything of that sort. Some other times, we may have to say to the executor, look, you're wearing too many hats. Maybe your personal interests are overpowering XYZ. Maybe you need to step back. Or more often, what we say is, you actually have to have two different lawyers for your two different hats so that you have two different layers of protection to make sure you're acting fairly in both situations. So you might have to get like a third lawyer involved, one to deal with as the estate executor, and one as, in your potential beneficiary's shoes where you're fighting with sister A for return of that asset, right? So those potential conflicts of interest do arise as for the PR situation, depending on the type of your dispute that you're dealing with. So again, you just have to recognize it whenever you're wearing more than one hat, there's a potential conflict of interest there, and you have to take the appropriate measures to make sure you're not overstepping the boundaries in one way or another, okay? So my last thought here, the final slide, is that, all of these, with even the best of planning, you may not be able to avoid all disputes, right? People, if they want to fight, they are going to fight. And people will bring claims if they want to bring claims, despite your best planning or best mediation efforts. But what you can do with some advanced tools, or if you think about it in advance and have a plan of action in place, is you can either minimize the possibility of a potential fight, or you can mitigate the impact of it so it's dealt with in the most efficient manner possible. Okay, so So that's my presentation today. We have a little bit of time left for questions. I know there's been a number of questions, so maybe I'll maybe have Matt start feeding some of those questions to me. We can group them together so we can answer them. Answer as many as possible.
Yeah, for sure. Thanks for that, Patty. That was extremely informative. I hope everybody thought it was just as good as I did. But you're right. Tons of questions here. More than likely, we won't be able to get to all of them, so we apologize in advance for that, but we'll try and get through as many as we can here in the next 10, 15 minutes or so. There's been a question right off the bat that has to deal with animals. If the deceased considered an animal as a family member and wants it taken care of, but does not set out who and how in the will, how does one go about managing that?
That's a topic close to my heart. As Matt, you mentioned, I'm an animal lover and I constantly worry about what happens to my dog. I say this, and I don't like saying this, but technically animals are assets. They're property, right? I view them as, my family member. They absolutely are. They're my children. But in the eyes of the law, we are dealing with assets. So as with all other assets, it's technically the PR's job to decide what to do with that particular furry family. If it's not settled in the will, you can use your best judgment, right? You can say, okay, well, who wants to take this animal? Who will take care of furry dog? And the difficult part may be the monetary portion of it, if there's a huge cost associated with a particular type of animal. Again, it's up to the discretion of the PR. And if it's not settled in the will, you treat unfortunately that little four-legged creature as any other asset. You deal with it the best way possible, give the best circumstances possible, depending on what the situation is of the estate.
Okay, great. Hopefully that helps. Regarding the memorial or funeral service, where the beneficiaries have strongly differing opinions, how should these issues be resolved? What is a reasonable amount to be spent on a memorial or funeral?
Generally speaking, the executor has the final say. Okay, so push comes to shove, if the executor wants to say, no, this is the way we're going to do it, there's too many opinions, there's too many cooks, I'm just going to pick one. Technically, the executor is allowed to do that. Having said that, it is a gray area. You want, as an executor, you don't necessarily want to just blow everything up right at the beginning over funeral arrangements, and most executors will try to tread through the middle, kind of find that middle ground between all family members. But you do have to remember, as an executor, at the end of the day, it's your responsibility and your job to deal with it, so you have the final say. In terms of how much you spend, it depends on the estate, it depends on that person. So we always talk about it, you have funeral arrangements. Sometimes the deceased will give you their directions. You don't actually have to follow it, because you're the person who has final say, but it's whatever is appropriate for the dollar amount of the estate. So if you have $1 million estate, it might be appropriate to spend $20,000 on a funeral arrangement. I'm not saying those are the numbers, but I'm just saying it might make more sense. But if you have a $50,000 estate, it's absolutely not appropriate to spend $20,000 on a funeral. So it depends on what the estate dollar value is.
Okay. Makes a lot of sense. If there is a will designating the spouse as the executor and there are no children and the spouse is the only beneficiary, does the executor have to apply for a grant of probate?
Again, it goes back to that previous question we had answered. It does depend on the type of assets that you have in that particular estate. Most commonly, if you have any kind of real estate that is only held in the name of the deceased, usually the number one reason to apply for a grant of probate, because without probate, land titles won't let you transfer the name to anything. But again, it really depends on what the asset base is and what assets you're dealing with.
Sure. If the will provides a beneficiary the testator's interest in a property, but the property has been sold before death, what is the beneficiary entitled to?
That's a very complicated law school question. we have what we call specific bequests and residual bequests in will, right? In a will. So what it sounds like you're talking about is a very specific bequest. One person is designated to get this particular asset. So if that asset no longer exists at the time of death, speaking in very, very general terms, then that person that beneficiary is no longer entitled to what doesn't exist. But again, there are certain situations which may change that. So that's just a very general answer that there, and it might depend on the specific situation of that case.
Okay. Is the executor obliged to share the will with all beneficiaries, even if not requested?
Yes, no. So it depends again on the beneficiary. So specific bequests, a specific bequest beneficiary generally does not have a full entitlement to see the whole will. Residual beneficiaries generally do. And if you apply for any kind of grant of probate during the application process, usually do provide a copy of that will as part of that application.
There was an interesting question. I'm just trying to dig it up here about someone on AISH. Give me 1 second. Well, I found another one while I'm looking for it. Can the government bring a claim on behalf of an adult disabled child if the child is in government care or hospital?
So if we're talking about FMS claims, family maintenance and support claims, so if there's a child out there, adults otherwise, who may have a potential claim against the estate, the person who brings that claim on behalf of that adult, because presumably that child doesn't have the capacity to do so themselves, the person who is designated their guardian and trustee will generally have the ability to bring that claim. So if that happens to be quote unquote one of the government departments, so if you're thinking of like the Office of the Public Trustee and whatnot, it's possible that those, if they're the ones who have guardianship and trusteeship over that particular person, can bring that claim. But again, whether they do so or not, or what the circumstances are under which they do or do not, is again very fact specific to that particular circumstance. And there could be, it's a very complicated set of factors that you would look at when it comes to whether a government entity will bring that particular claim.
Okay, I found the one about the person on H. Can an executor decide that the gift in a will left to an individual who is on H would be wasted, and thus that person's gift withhold that person's gift, like not give the designated amount?
So I'm not sure what you mean by wasted, but I think generally speaking, the executor doesn't have the ability to just unilaterally decide whether a gift should be given or not. So if it's set out in that will, that's XYZ person gets that amount or particular thing, the executor doesn't get to say, you know what, I think that person, for example, would just like squander it, or it's not in their best interest to get that money, because we've heard those before. The PR generally doesn't make that call. Your job is to administer according to that will. The recipient can choose not to take that gift. And again, the only reason I mentioned that is because, you mentioned an AISH beneficiary. Sometimes there are some calculations involved, and because of the way the structure of the AISH structure is, taking a gift or whatnot may be beneficial or may not be. So sometimes there's factors like that. A beneficiary can decline a gift, but generally speaking, a PR does not unilaterally decide that that beneficiary should not get a gift just because they think it may not be used properly.
Okay, so we're running out of time, so maybe we'll do just one or two more here. So again, apologies to those we can't get to, but really want to be conscious of time for Patty, who's volunteered her time to be here for us today. So
I'll get to an extra 5-10 minutes if you are, Matt.
Okay, sure. Yeah, if we want to do another 10 minutes or so, then absolutely. That sounds great. Still likely not to get to everything, but we'll get to a bunch. What happens when a family member or family members cannot afford to pay for legal advice during a dispute?
Yes, and this is something that we deal with quite often, and we're talking. So when you're saying family members, perhaps I don't know if you're talking specifically in the FMS type situation, that definition of family member, or just family in general. But when parties can't I know lawyers are expensive. I completely recognize that. And we see this over and over again. We do see lots of people self-represent, and you're perfectly entitled to self-represent yourself as a self-represented litigant. It does pose a few challenges to the PR because a self-represented litigant obviously may not know the processes or the law all that well. And as a PR, you have to be extra careful or considerate in dealing with a self-represented litigant, that you don't feed them like the wrong information, or, like you take one position, they're obviously entitled to take another. And if you're dealing with a lawyer on the other side, that's fine. Like we just argue for a living, right? But when you have a self-represented litigant, you have to be much more careful about that. So that person can self-represent themselves. It does usually make the PR just a little bit, their job a little bit more difficult, but that's the nature of the beast. There are sometimes there are certain applications that particular person can make in terms of security for costs or distribution, whether from the PR side and whatnot. But those are a little bit rarer and again, a very complicated area that isn't always utilized for that.
What if an adult child has been included for some financial help, much less than normal, because he or she has serious lifetime problems and has been in effect disinherited? But could this person still cause threat to the estate for being left out of basically being disinherited?
Right. So the answer to that will depend on whether that particular adult falls under the category of family member under that FMS claim. So if that particular adult is, for example, someone who has a disability and by virtue of that disability cannot earn a livelihood, then that person can go ahead and bring a claim against the estate and say, I have an FMS claim because I didn't get left enough money for my adequate support. So in that sense, if that's the situation, that adult might be able to make a further claim. Absent something like that falling under FMS claim, generally speaking, and you can choose who you leave your money to. But I say this, and then I also say it also doesn't stop that adult to try to raise a ruckus about it. So, things like challenging the validity of the will, saying maybe you didn't have capacity at the time that deceased signed the will, doesn't stop challenges like that. But it generally does. You generally do have the ability to leave your money to who you want to. I would probably say, make it very clear to everybody involved in your will as to why a particular child receives a lesser amount, or, so again, your intentions are as clear as possible, that it's not a mistake. And you make that clear there.
Okay. Sort of sticking along some of those lines, can we sue our sibling for his share of the inheritance? The sibling has been estranged from mom and us over several years and has not offered us any help or to pay for any different items.
I think the general answer there is probably no. Because first of all, you would have to find an obligation on part of that child, that sibling, to have paid for stuff, right? So, generally speaking, in our laws right now, there's no obligation on part of an adult child to take care of an older parent. That's just the way it stands right now. So there's no basis for which you can sue. If on the other hand, he owes mom money, for example, like he borrowed money from mom, so sure, those are one of the claims that you would then be able to go after as a personal representative. And it might be offset against certain portions of his entitlement.
Okay. This one's a relatively more generic question. When there's a dispute or a disagreement on disbursements, what does the PR do? Wait for the disagreeer to start legal action, or what?
Again, I hate to say this, but it's all very situation specific. So and I think for the sake of other people, what we're dealing with is if what the executor is doing is being challenged. So like, what you're doing as an executor, not a dispute within the estate, but one of your beneficiaries challenges you as an executor and what you've been doing, and talks about the disbursements. So we do it a number of different ways, depending on what the situation is. You could wait until they sue. Probably a little bit better to be more proactive and address the issue head on, either through like a settlement proposal, provide more information. A lot of the issues that we see stem from either a misplaced sense of they think you misappropriated something, right? And that can be remedied by providing more information, the documentation behind it, giving them information that they require, building that trust again. Probably being more proactive would probably be better at resolving the matter. You don't always have to wait for people to sue to try to resolve that issue. But again, depends on the situation, right?
And we'll do a few more here because now we have taken up a little bit of extra time, but a couple more for this. You did touch on this towards the end of the presentation, so I'll pull this one up. What happens if the deceased verbally told his kids about certain specified assets to go to his kids, but did not mention it in his will?
So then what you generally have is a he said, she said situation, right? We always like things in writing because it's in black and white and everybody can read it and they know it's there. But absent that, right? Because if everyone put everything down in writing, us lawyers wouldn't have a job, right? That would be the ideal world. Everyone put it down. Absent that, though, what you have is he said, she said. Now, if that deceased said it to everyone and there's 10 people who heard it all at the same time and all heard the same thing, then what you have is pretty strong corroborated evidence. Then the deceased had told 10 people who can individually vouch for it. And that would be evidence saying that's what his intention was. It's a little bit trickier if he only told one person in a private conversation in a room somewhere that nobody saw, nobody knew they were having a meeting, there were no notes taken. Then you're faced with a situation where if you go to court, for example, you have to convince the court who to believe. And again, we need corroborated evidence. We need something to back it up. Yeah.
And so maybe to wrap up, we'll do one more here that just kind of piggybacks on that. How long can disputes end up in court, and who ends up paying for the legal fees?
I've seen disputes, get resolved in 3 months. I've seen them drag on for 10 years, right? 10 years is usually rare, but it does happen. In my world, unfortunately, 10 years doesn't surprise me. 3 years doesn't surprise me. You're probably, if you're going to go through the whole court process of a particular dispute, you're probably looking at, I would say right now, 3, 4, or 5 years wouldn't surprise me at all, just because of our court system being a little bit slower. In terms of legal fees, while you're going through the litigation process, a lot of the times, especially if you're the person bringing the claim, you're paying for those legal fees out of pocket at the time. The estate will likely pay for the fees of what the executor has to incur. And then at the end of the day, if you go to court, the court ultimately will then decide where the costs get paid, whether someone gets reimbursed by the estate or not. And the factors that go into is who wins and who loses, right? The factors that also go into it as to whether the estate ultimately starts paying for the costs of other people involved will also be things like, okay, well, was it something that the testator did that put this mistake, like there was a mistake made by the testator or something, a situation that the testator caused. That's why everybody was in court, because nobody knew what the testator wanted or what his intentions were. So maybe it will only be fair for the estate to pay for it. That happens as well. But the court at the end of the court case does get to decide, that redistribution of costs, if any. It's completely within the discretion of the court.
Okay, great. Well, I think we'll end there because we did go a little bit over time, so we appreciate you sticking around a little bit longer than advertised. So just before we wrap up, a huge thank you to you, Patty, for taking the time to present such an informative presentation. Hopefully our audience got as much out of it as I did. It certainly seemed like they were very engaged based on all of the questions in the Q&A, and I do again apologize that we can't get to all of your answers. That said, if you would like to have some follow-up conversations with Patty or any of the lawyers who have presented during this estate administration week, feel free to reach out to us at ECF. We can provide you with some contact information for our volunteer lawyers, and we can certainly put you in touch with anyone that you might want to have a follow-up conversation with. So, and then again, if your question didn't get answered, perhaps there is some information that could be valuable to you on some of the previous sessions that have been delivered. So stay tuned for those recordings to be posted on our website. There are still a few more to go this week, so feel free to visit ecfoundation.org for more information on what we have presented or what's still to come this week. So